Welcome to the first edition of Dynasty Risk and Wealth Services monthly vlog. My name is David Hannaway, and in today's edition we're going to be discussing wills and estate planning. What we thought we'd do for this edition is we get a lot of queries from our customers around wills and estate planning. So we're going to go through some of the commonly asked questions today, and we're going to kick it off with a very simple one of, are there more than one type of last will and testament? And the answer is simple. Yes, there is. You get a single will. A single will is really just a will of the last will and testament of one person's wishes and how to distribute their assets. You get a joint will. A joint will is basically two separate wills combined into one document. For example, a spouse's wishes and another spouse's wishes. They're completely separate wills, but they are in one document. And then to end off, you get something called a mutual will, which is one kind of joined estate, whereby it's the same document, it's a combined estate, and basically what happens there is when a deceased passes, the estate forms part of the mutual estate, as it were. Fun fact: you used to get something called a soldier's will, which was for the Navy and Air Forces and so on, but those no longer exist. A living will is an incredibly important type of will, whereby if somebody is medically unable to make decisions, a living will acts as an ability to assist the wills and the wishes of that person. I think for me, a question we get a lot is, can I update my will? And the answer is simple. You can update your will at absolutely any time and as often as you like. For me, some really important times that you would want to update your will are at marriage, divorce, and various other life-changing events. But there's no limit to how many times you can update your will. A really great question we got asked a couple of weeks ago was, what if I can't physically sign my will, as in kind of physically signed with a pen and the will itself? The Estate and Wills Act does allow you to actually sign it via a fingerprint, but it has to be in the presence of a commissioner of oaths. In line with that question on the concept of signing of a will, one big thing that we discuss with our customers often is, in order for a will to be valid, there's some very important things that need to be present on the will. First of all, it has to be signed by somebody over the age of 14 who is sound of mind, which is, if they were to appear in front of a court of law, they were sound of mind. It cannot be signed by somebody who benefits from the will, and it must be dated correctly. Basically, those are a lot of the times the reason we get invalid wills. And you know, I think for me, the question of kind of a valid will really comes down to getting professional advice, because oftentimes anybody can go and buy a will from a retail store, whatever it may be, but it's how to formulate the wishes, how to actually make the will valid, is where us as professionals come in hand. You know, we have a deep understanding of the Wills and Estate Acts, and we can really give people advice on how to make sure that the wishes you have in that will are as executable as possible. We came across quite an interesting question a couple of weeks back now, with somebody who requested information on how, if they've got nobody to leave anything to but their special needs child, how do we construct that will for them? And it's quite a complex process, but we can simplify it for you. Effectively, it's called a provider's trust, which is a testamentary trust that we construct within the will to make sure that we can, through proper planning, from a liquidity perspective, for example, life cover, etc., make sure that we can provide for that person, because they're not able to provide for themselves effectively for as long as is needed. In theory, you could provide for them forever. Something that happens a lot in South Africa is people have offshore assets. So we get asked a lot, what happens to my offshore assets? Do I need a separate will for those? And again, the answer in our world is actually quite simple. You really don't. We can do something called a worldwide will, which is able to incorporate all your assets overseas into one will. Those assets need to be in a Commonwealth kind of country though. Anything outside of that, and you really need to come and get some advice from us, because that's where things can get a little bit more complicated. Some fun facts for today. Are video wills and wishes valid? Sure. I think at some point maybe, but right now video wills and wishes are definitely not valid whatsoever. And I think for us as professionals in the space, we get asked a lot, why should I have a professional kind of drafting my will? And the answer, again, I've kind of mentioned it over and over again today, is very simple. You need to make sure that what you really want to achieve out of your estate and what you want to leave for people is actually able to be actioned and executable, as we call it. It's no good having all these wishes that in theory haven't been formulated properly, and so you can't they can't be actionable. You know, I've been asked to discuss the concept of, should my funeral arrangements be left, should be kind of indicated. Well, the answer is no. Estate planning and kind of wrapping up an estate happens very far after that. So generally you need to let somebody that's very close to you, as a fact that you know is going to be able to kind of work with your funeral and sort out your funeral. They need to know exactly what your wishes are there. Because that happens a long time before all the things that we do in the background, the liquidation and distribution account and all that stuff happen. To end off today's session, I suppose for me, in one sentence, I've been asked to describe what really is the fundamentals of estate planning. It's, in my view, simple. To make sure that proper planning has been done, that what you really want to happen once you are no longer here can be executed, that there's enough money and assets and so on to be able to leave your family in the same financial position that they were, and to make sure that the only thing at that point in time they're dealing with is emotional hardship and not the financial hardship that can sometimes come with the passing of a loved one. I really hope you guys enjoyed today's first session of Dynasty Risk and Wealth Services monthly vlog, and look forward to other sessions where we're going to unpack a whole bunch of other different topics, from insurance to investments and all the rest. Take care, and we'll see you guys soon. Cheers.